Good morning, good afternoon, good evening, wherever you're joining us from. I'm Dr. Meagan Wong. I'm a lecturer at Essex Law School, where I'm also the director of the LLM in International Law degree. And together with Dr. Emily Jones, we are the co-founders and co-conveners of the Public International Law lecture series, and we're so pleased to have you join us today. We are especially delighted to have our speaker, Dr. Jula Dehm, today, whose lecture is entitled Accounting for Carbon, Targets, Inventories, and Risks. So welcome, Dr. Dehm, and thank you so much for accepting our invitation to speak and be here with us today. For those of you who are joining us for the first time, Dr. Jones and myself are pleased to present the Public International Law Lecture Series. And for those of you who have attended our series before, welcome back. As my role as host, I just wanted to speak a little bit more about the Public International Law Lecture Series before I leave the floor to Dr. Jones and Dr. Dehm. So this lecture series is built upon two important intellectual traditions of public international law, formalism in international legal practice, and international legal theory, including post-colonial and feminist perspectives. So the idea for this series stems very much first and foremost from our friendship and has always been inspired for our deep respect for each other's scholarship and research, and of course, our days as colleagues teaching public international law together. Dr. Jones and I are both generalist public international lawyers with several specialist interests, but we engage with international law from different approaches. I'm a formalist, and Dr. Jones is a critical legal scholar, which inspired the idea for this series that we co-founded together because we really enjoy bringing forward cutting-edge discussion in international law from varied and different frameworks, theory and practice, and we just really hope it's something for everyone. Now, I will introduce our chair for today, Dr. Emily Jones. She's an NUACT fellow based in Newcastle Law School, Newcastle University. Dr. Jones is a generalist public international lawyer whose interdisciplinary work combines theory and practice. Her work broadly examines modes of resistance and hope, drawing on feminist, queer, post-human, decolonial, and critical disability studies in that aim. Dr. Jones's work spans across several fields of international law, including international environmental law, the law of the sea, international human rights, law, science, technology and international law, international disarmament law, and outer space law, amongst many others. Her monograph, entitled Feminist Theory in International Law, Posthuman Perspectives, was published with Routledge's Glasshouse series in 2023, and she's also the co-author of The Law of War and Peace, A Gender Analysis, Volume 1, and as well, she has co-edited 2 volumes, International Law and Posthuman Theory, and the more posthuman glossary, and undoubtedly many more scholarships and monographs to come. So with that, I now leave for Dr. Jones and Dr. Dehm to have the rest of the session.
Thanks so much, Dr. Wong, and it's a real joy as ever to be here with you today. And it's my real pleasure to introduce today's speaker, Dr. Jula Dehm, who for me is one of the most groundbreaking scholars in international environmental law of our time, really. So I'm really, really happy that she was able to join us today. More formal introduction, Dr. Jula Dehm is a senior lecturer in the School of Law at the Trobe University, which is in Australia. Her research addresses urgent issues of international and domestic climate change and environmental law, natural resource governance, and questions of human rights, and economic inequality and social justice. Her books include Reconsidering REDD, Authority, Power and Law in the Green Economy, which came out with Cambridge University Press in 2021, as well as Locating Nature, Making and Unmaking International Law, which she edited with Usha Natarajan, and Power, Participation and Private Regulatory Initiatives, Human Rights Under Supply Chain Capitalism, which she edited with Daniel Brinks, Engle and Kate Taylor. She was also previously a consultant to the UN Special Rapporteur on the right to adequate housing assistance and a 2023 member of the School of Social Science at the Institute of Advanced Studies in Princeton. As Dr. Wong mentioned today, Dr. Dehm will be speaking to the title of Accounting for Carbon, Targets, Inventories and Risks. Now, just a very few quick housekeeping things before we begin. If you want to ask a question, there's a kind of Q&A button at the bottom of your screen. So you can ask a question at any time. So if you're kind of listening to the lecture and you're like, I really want to ask that, like feel free to type that in, that's totally fine. But I will, of course, be putting these questions to Dr. Dehm at the end of the lecture. You can remain anonymous when asking a question, and if you wish to do so, you have a little tick box that you need to use. If you don't do this, then I will be reading your name out. So that's it from me. Without further ado, Dr. Dehm, over to you. And thank you so much for joining us today.
Thank you so much for the invitation to be part of this wonderful lecture series, and thank you to everyone for coming and joining us today. Before starting, I want to acknowledge that I'm speaking to you from the stolen lands of the Wurundjeri people, and that their sovereignty over these lands and waters has never been ceded, and to pay my respects to their elders past and present. Quickly try and share the screen. So accounting can refer to both the process of quantifying, counting and measuring, but it also refers to obligations that are owed to one another. To call someone to account is to require them to explain a mistake or a poor performance. In this project provisionally called Accounting for Carbon, I want to think through the concept of accountability in relation to the climate crisis and critically unpack how technical questions of metrics and measurement have political effects and thereby open up or foreclose different forms of responsibility. So I'm still in the very early stages of a book project by this title, and therefore what I hope to share with you are some quite initial explorations and to situate some of my thinking in light of my previous work. Given the entire premise of the project is that some technical questions have political implications and effects, apologies for an advance for what might be a technical discussion. One sec, how do I turn this? So the animating concern in my previous book is that the dominant international legal responses to climate change, particularly the marketized vision of a green economy, replicate and indeed further intensify already existing legal relations of domination, exploitation, and marginalisation. It focused on a particular mitigation scheme called reducing emissions from deforestation or forest degradation, often referred to by its acronym REDD or REDD+. Since it was first proposed in 2005, REDD has been highly controversial, and although still not formally confirmed, REDD is envisioned as a carbon offset scheme that would allow countries from the global north to provide financial assistance to promote the reduction of deforestation and forest degradation in the global south, and in return use the credits from the saved carbon dioxide towards their own international mitigation commitments. And there have been acute concerns about the impacts of these schemes on the 1.8 billion people, approximately 300 million of whom identify as Indigenous, who live in and around forested areas, especially given the long histories of coercive or fortress conservation that's dispossessed people from their lands. So grassroots Indigenous and climate justice activists have critiqued REDD as a land-grabbing false solution to climate change and as a new form of neo-colonialism or CO2 colonialism. My book builds on these critiques and argues that REDD needs to be analysed not just as a problematic false solution to climate change, but also as an ambitious project that is reorganising how forested land in the global south becomes an object for international and transnational regulation. It shows how REDD operates to reorganise social relations and to establish new forms of global authority over forests in the global south. And part of its contribution is showing how even the main strategies promoted to protect forest peoples from the potential adverse impacts of REDD, namely tenure reform, benefit sharing, and free, prior, and informed consent, shouldn't be understood primarily as ameliorative, but rather as themselves productive of new governance relations. I suggest, therefore, that these safeguard mechanisms may in fact operate to create the forms of legibility, subjectivities, and social relations that further consolidate the reorganisation of authority that REDD represents by facilitating the greater disciplinary inclusion of forest peoples in the so-called green economy, including by transforming them into ecosystem service providers. So my current project takes up two of the main concerns underlying my previous work. Firstly, how technical practices of measurement and monitoring enable marketised approaches to climate governance by making complex situated metabolic interactions legible in terms of emission reductions, that are imagined as standardizable, exchangeable, and commodifiable, and ultimately tradable. That is, it's concerned with these questions of how the natural world is remade into natural capital or ecosystem services through practices of valuation and the legal construction of new forms of property rights and markets. The second underlying concern is with responsibility and how international legal responses have enabled the persistent evasion of responsibility by those who've done the most to cause the climate crisis and instead promoted the responsibilization of those least responsible for the climate crisis and most vulnerable to its impact. Through a focus on accounting and accountability, this project tries to hold together technical questions of measurement with political questions of responsibility. And there is, as these headlines show, an acute concern at the moment in media and sort of political debate about how existing climate accounting frameworks are being manipulated by various accounting tricks. However, the assumption underlying such headlines is that we just need better and more transparent rules and frameworks. They therefore fail to take seriously how calculative practices are themselves technologies of governance that shape social and economic relations. And I think it's helpful to turn to art to sort of speak to some of the absurdity of our current frameworks. So this artwork by Tega Brain and Sam Levine Offset provides a more political critique of the politics of carbon accounting. They present an alternative carbon neutralisation register that purports to generate high integrity premium carbon credits from industrial sabotage and direct action, thereby, they joke, contributing to a program of highly financialised radical change. Although this is a satire, Nicholas Barrett has critiqued how this focus on counting carbon has become so hegemonic that activists who shut down a power station in the UK justified their action in terms of how much carbon has been saved from entering the atmosphere through that action. Yet, given the underlying concern of such protests is about how certain futures are materially produced in the present through infrastructures, Barrett calls instead for an account of infrastructures as socio-technical arrangements that reproduce particular forms of life. And it is thus to those questions of infrastructures and the forms of life they enable that I hope to turn to in the conclusion of the book. So having now spoiled the ending of the book for you, I want to talk through some of the questions of methodology and the structure of the project. So one of the things that I'm still working through is how to productively think about the terms accounting and accountability. Accounting, as Peter Miller argues, is a body of expertise focused on extracting responsibility from individuals rendered calculable and comparable. Accounting practices and tools have mutated and adapted to different social conditions and in response to ideological struggles over the distribution of wealth and in response to social conflict. Most scholars date the concept of accounting to the Doomsday Book produced after the Norman invasion of England, but recent scholarship has highlighted its implication with colonialism and slavery. Eli Cook shows the role of political aromatic in the 17th century conquest of Ireland, and Kathleen Rosenthal argues that slavery became the laboratory for the development of accounting. Control, Rosenthal reminds us, has always been the heart of modern accounting practice, and accounting books bear witness both to the control exercised and its limits as it encounters resistance. Accountability has been described as the buzzword of modern governance, with some scholars suggesting that accountability is emerging as an uber concept of the 21st century. Its rise is closely tied to the emergence of a managerially orientated style of governance promoted by new public management reforms that brought the private sector management styles to the public sector. Along with participation, consensus, effectiveness, efficiency, equity, and inclusiveness, it is, as Wendy Brown has shown in Undoing the Demos, a central element of the neoliberal good governance agenda. The literature describes accountability as a virtue or a goal, but also in terms of an administrative mechanisms, or the institutional relation or arrangement that allow an institution to hold another actor to account. Mark Bovins defines it as, and I quote, the obligation of an actor to publicly explain or justify conduct to some significant other. In thinking about accountability, we thus need to pay attention to how demands for accountability have specific effects and constitute subjects in particular ways. However, it's also critical to pay attention to the crucial distinction between an obligation to publicly explain or justify conduct and actual obligations or duties that are owed to another. Beyond the language of accountability, there is, I suggest, a broader need to ask questions about who owes obligations to whom, to do what, based on what underlying claim to authority and the institutional means by which these obligations are or could be enlivened. So turning now to the broader structure of the project. So the project's organised around three main topics or chapters: targets, inventories, and risks. And in this talk today, I want to share some of my initial work on the theme or topic of targets. Targets or objectives are expressions of goals that set out what is aimed at or sought to be achieved through action. They thus frame what type of action is pursued and how success or failure is measured. My focus is on the international climate regime and the way in which the targets of the regime have been framed, how they have been quantified, and how the means of achieving them have been conceptualized. But before discussing targets in more details, I quickly want to provide an overview of the other two topics, inventories and risks. So inventories are a critical accounting tool. The term, derived from the late Latin invarium, literally means a list of what is found. The international climate regime has adopted the approach that national inventory should focus on greenhouse gas emissions and removals taking place within national territories and offshore areas over which a country has jurisdiction. This approach has a number of immediate and obvious problems. It excludes emissions from international aviation and from international shipping, as well as from military activities from the international regime. More fundamentally, this nationally bounded approach is inadequate in the context of the international economy, where production is increasingly organised by spatially disaggregated through global value chains. It attributes emissions to the country where goods are produced, not where they are consumed, although current regulatory proposals for a carbon border adjustment mechanism that seek to address this. It also allows fossil fuel exporting countries to abrogate responsibility for the emissions contained in their exports. Australia, for example, the world's third largest fossil fuel exporter, has consistently made this argument, which has until very recently been uncritically accepted by courts considering permits for new coal mines. Just today, too, we had the full court of our federal court again accepting the Minister for the Environment made no error when she relied on this market substitution defence in saying that we're not obliged to consider the impact of climate change when approving new coal mines. Different ways of attributing emissions to other entities, for example, corporate carbon majors, has opened up possibilities for new legal arguments about liability or responsibility. This sort of accounting framework now underpins a number of pending climate litigation cases, including the Transnational Court, Louisiana and RWE, where a Peruvian farmer is suing the German energy giant. However, as well as thinking beyond the national frame of current inventory models, I also want to think about what is being itemised on these inventories and how we can think beyond emission reductions to better focus on the transnational technological, social, economic and financial systems that underpin the extraction, circulation and combustion of fossil fuels. So finally, turning to the question of risks. In the past decade, climate change has increasingly come to be understood as presenting certain physical and transition risks for companies, for investors, for insurers, and indeed for the global financial system as a whole. This has opened up new legal questions about the obligation that corporate directors or fiduciary trustees are under to disclose and manage such risks. However, rather than focusing just on how to manage the risk that fossil fuel reserves and associated fossil fuel infrastructures could become stranded assets, I want to try and understand how it is that fossil fuel reserves, which are still physically underground, came to be economically above ground and have economic value. This is a story both of valuation techniques, such as discounted cash flows, that have valued these reserves based on expected future profits, and thus allowed these expectations to be factored into share prices. However, it's also a story about legal rules that enable the judicial protection of assets, especially the rules that allow corporations to sue governments if they're prevented from realising this value. And so domestically in the US, this is sort of takings clause jurisprudence, which you can see here referred to in a newspaper article about the Willow Project. And internationally, as we know, there's a whole array of bilateral and multilateral investment treaties that allow corporations to sue governments for the expropriation of property. And these are already being used by fossil fuel companies to sue governments for climate policy. Having briefly set out what I hope to explore in more detail in work on inventories and risks, I now return to the main theme for today, which is targets. So throughout the 30-year history of the international climate regime, its targets have been reframed and reconstructed various times. And articulation of these targets reflects the co-evolution of politics with climate science, climate modelling, and technological development. The underlying political concern driving this investigation is that after 3 decades of international climate negotiations, emissions haven't slowed, we haven't bent the emissions curve. Just last week, we had headlines again about a massive jump in emissions from last year, again, and one of the biggest jumps that we've seen. So not only are we not cutting emissions, we're not cutting the rate by which they're growing. There's thus a fundamental question about how the articulation of targets is allowed for the avoidance of limits. So in thinking about targets, I want to unpack historical struggles over 3 interrelated questions. Firstly, how the objectives of climate policy have been framed. Secondly, how these objectives are quantified, that is, into specific temperature targets. And thirdly, how flexibility is introduced into how these targets are achieved through the notion of net zero. These stories all have a similar starting point in the mid to early 1970s, and a period that's so central to the shaping of our present. It's a period that's marked by the oil crisis, by contested discourses of ecological limits, struggles over economic inequality within and among countries, and new technological paradigms and innovations, and of course, the neoliberal counter-revolution. The 3 stories I want to tell intersect in important ways, but I'll try and give you 3 separate accounts and bring them together at the end. So turning first to the question of how the objectives of climate mitigation have been framed. So COP26 in 2021 in Glasgow broke a taboo, as some said, by including for the first time in 30 years of climate negotiations, a reference to phasing out fossil fuel subsidies and the phasing out of a fossil fuel, namely coal. Although the language of the decision left much to be desired, it was nonetheless significant to specifically name fossil fuels, given that the burning of oil, coal, and gas are responsible for 86% of carbon dioxide emissions. Underpinning this focus on phasing out fossil fuels was the scientific idea of a global carbon budget, the cumulative amount of allowable carbon emissions to meet a global temperature target, a concept which gained prominence after it was endorsed in the IPCC's 2014 Fifth Assessment Report. Given that existing fossil fuel reserves exceed this budget many times over, the concept has galvanised thinking about the need for supply-side climate policies that address the production of fossil fuels to complement the traditional focus on supply-side policies that address consumption. In contrast to this focus on fossil fuel production, the 1992 United Nations Framework Convention on Climate Change frames the problem of climate change as one of increases in the atmospheric concentration of greenhouse gases. The objectives of the treaty are therefore to achieve the stabilisation of greenhouse concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. So what turns on this difference? While the story is more complex, I suggest that in the early to mid 1970s, when climate change started to become a policy concern, we start to see emerging in the scientific literature 2 competing imaginaries, what I call a carbon budget and a carbon cycle imaginary. Although the scientific studies all identified the burning of fossil fuels as the primary cause of increases of greenhouse gas emissions, during the 1970s, more and more papers highlighted how atmospheric CO2 depends on both the rate of fossil fuel consumption, as well as how these emissions are absorbed by and interact with the biosphere and oceans. This led to important calls for research into biospheric carbon and the carbon cycle, but these uncertainties were also mobilised to argue that changes in energy policy could not yet be justified. As one piece concluded, it's premature to reduce the use of coal or other fossil fuels. After a number of high-profile scientific conferences, the 1988 Toronto Conference on the Changing Atmosphere was the first meeting to bring together scientists and policymakers internationally. The conference statement still foregrounded inefficient and wasteful fossil fuel use. At the conference, high-level speakers stressed the imperative to act now and called for an international law of the atmosphere and an action plan for the protection of the atmosphere. It also called for a World Atmosphere Fund that would be financed in part by a levy on the fossil fuel consumption of industrialised countries. For many commentators, the notion of an international law of the atmosphere invoked the international law of the sea, and thus also one of its key organising principles, namely the idea of common heritage of mankind. This principle, initially proposed by Malta in the 1960s and promoted by third world states, rejected the notion that appropriation of deep sea mineral resources should proceed on a first-come, first-served basis, but rather that exploitation should be subject to international management and that there should be an equitable sharing of the benefits of exploitation. Later that year, in December 1988, Malta proposed a General Assembly resolution that applied the principle of common heritage of mankind to the atmosphere. Although the General Assembly welcomed Malta's proposal, the subsequent resolution instead described climate change as a common concern of mankind. While the idea of common heritage assumes that the atmosphere should be held in trust for future generations, making present generations trustee with quasi-fiduciary obligations to those who come after, the newly formulated concept of common concern does not create specific rules or specific obligations, but just, and I quote, establishes a general basis for the community concerned to act. In jurisdictional terms, we could say that this concept, which was later enshrined in the UNFCCC, authorises new forms of global authority based on this common concern, but does not enliven any corresponding obligations. A February 1989 meeting of legal and policy experts developed two alternative proposals, a Convention on the Protection of the Atmosphere and a Convention on Climate Change, and they pushed back against the General Assembly Declaration, characterising the atmosphere as a common resource of vital interest to mankind. In March 1989, the Hague Conference, which brought together representatives from 24 governments, although not the US or the USSR, called for the development of new institutional authority to protect the atmosphere and combat global warming. The US had been relatively absent from these discussions, but facing domestic pressure to act, it started to engage in a way that allowed it to influence and shape the outcomes of international negotiations. In internal policy documents, it worried about the cost of cutting coal would be immense, and therefore foregrounded the major uncertainties about offsetting effects, including of dynamics of the ocean and atmosphere interface. The US considered an international law of the atmosphere or a sweeping law of the air premature. Instead, it argued for the need for more scientific research and pushed for the establishment of the IPCC. The US sought to make the IPCC, and especially the Response Strategies Working Group, the nascent Working Group 3, which the US chaired, the forum for elevating the desirability of a global convention. As the political momentum for an international climate convention grew, the focus was increasingly on emissions, not on fossil fuels. In July 1989, the G7 Economic Summit called for limiting emissions of carbon dioxide and other greenhouse gas emissions. And the November 1989 Nordvik meeting articulated objectives of, and I quote, CO2 emission stabilisation and future reductions, as well as a global forest stock balance and future net forest growth. However, most of the work of developing the elements of the eventual legal agreement was done by the legal working group established by Working Group 3 of the IPCC. An October 1989 workshop on implementation measures hosted by the US elaborated a list of possible elements. And the IPCC First Assessment Report, adopted in August 1990, included a chapter on legal and institutional mechanisms that included possible elements for inclusion in a framework convention on climate change. And this political role played by Working Group 3 was increasingly controversial. When the General Assembly adopted a resolution supporting negotiations for an international convention, developing countries pushed for the negotiations to take place under the auspices of the General Assembly, not the IPCC. While the IPCC too, there was concern that being the main forum for these early political negotiations was a threat for the scientific credibility of the whole organisation. The organisation subsequently withdrew from providing policy recommendations and reinstituted a strict demarcation between scientific assessment and political negotiation. By the time the Intergovernmental Negotiating Committee, established in 1989, tasked with developing the Framework Convention on Climate Change, had its first meeting in February 1991, the problem of fossil fuel dependency was no longer really part of these discussions. It was assumed the objective of the treaty would be framed in terms of greenhouse gas emissions, and the battles had now shifted to the questions of whether the treaty would contain binding emission limitation targets or only general principles, and if so, how those targets would be quantified. During the negotiating process, the US pushed for a comprehensive approach, They consider collectively all sources and sinks of different greenhouse gas emissions in formulating policy and allows them to compare it by a single metric, 1 tonne of CO2 equivalent, and address their net contribution to climate change. While this approach was not fully accepted, the UNFCCC preamble emphasises the role and importance in terrestrial and marine ecosystems of sinks and reservoirs of greenhouse gases. It requires that national inventories include emissions by sources and removals by sinks, and calls on all parties to promote the conservation and enhancements of sinks and reservoirs. And clearly, there is a need to promote both the reduction of emissions and the enhancements of sinks. My concern is, however, that when they're treated as substitutable ways of achieving a global policy outcome, especially when overlaid with the imperative to take cost-effective action and ensure global benefits at the lowest possible cost, a focus on international regulatory attention onto land and resources of the global south. It then focuses international regulatory attention onto the land and resources of the global south, while fossil fuel dependency recedes from view. In concluding this section, I don't want to suggest that organising the regime around different legal principles would have automatically produced different results. All legal concepts are subject to continuing debates over their interpretation and operationalisation. And the current extractivist boom that we're seeing in deep sea mining shows how the more radical potential in the principle of common heritage has now arguably also been neutralised. However, a carbon cycle imaginary and the associated framing of objectives in terms of stabilising greenhouse gas concentrations is more conducive to the fantasy of equivalence between emissions from fossil sources and sinks and a logic of substitution. In contrast, an imagery of carbon budget, especially when paired with the legal concept of common heritage, might be more conducive to thinking about the unequal historical appropriation of the atmosphere and the reparative questions this enlivens, as well as the need for tangible pathways away from fossil fuel dependency. So the second story I want to tell is how targets have been quantified in the international climate regime. The UNFCCC simply calls for the stabilisation of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the atmosphere. And for a long time, this very value-laden question of what constitutes dangerous anthropogenic interference with the climate system wasn't quantified in any way, nor was there consensus about what metrics should be used for quantification, whether parts per million of CO2 or various temperature targets. The 2-degree temperature target that's now enshrined in the Paris Agreement, along with an objective to pursue efforts to limit warming to 1.5 degrees, pushed for by small island states, was first articulated in the international climate regime in the controversial 2009 Copenhagen Accord. Yet the process of consolidating consensus around the 2-degree target started much earlier. It was initially adopted as a global target by the European Union in 1996, re-articulated in 2005, and affirmed that year by the G8. It remains a deeply contested target. All thresholds really authorise pollution to a point, and the impact of such permissible pollution are felt most acutely by peoples in the global south, Indigenous peoples and communities of colour in the global north. Famously, at Copenhagen, the Sudanese delegate described 2 degrees as a suicide pact that would sacrifice the interests of the majority of the world. While the story of the 2-degree target is more complex than what I have time for, I want to highlight the crucial role played by cost-benefit analysis in quantifying what constitutes dangerous climate change. The theory of cost-benefit analysis can be traced to 19th century welfare economics. However, its practice is dated more recently to the 1936 Flood Control Act in the United States. So after World War II, although through the convergence of economic theory, practical engineering, and operational analysis, cost-benefit and cost-efficiency analysis increasingly informed federal government action, especially Cold War military planning. These techniques migrated from the Rand Corporation to the Pentagon before spreading throughout the US federal government, which after 1965 required comparison of costs and benefits of programs prior to budget approval. During the 1970s, polluting industries began coordinating efforts to inject cost considerations into the language and methodology of environmental policy. And the biggest battlefield was the Clean Air Act. The Clean Air Act empowered the newly established Environmental Protection Agency to establish standards for air pollution based on the level necessary to protect public health, without requiring consideration of compliance costs or technical feasibility. Although the environmental justice movement is generally dated to the early 1980s, historians have recently shown how in the 1970s there were nascent radical coalitions of labour, civil rights, environmental activists who highlighted not just the disproportionate pollution in low-income communities of colour, but also the structural dependencies of those communities on the industries that poison them, and thus sought concrete solutions to that structural dependence. There was real potential for regulatory radicalism. David Bond has described how under pressures from citizen lawsuits, the EPA called for drastic reduction in fossil fuel use, and there was growing debate about whether hydrocarbon emissions should be tolerated at all. Affected industries went on a counterattack using sophisticated PR techniques, many of which we are familiar with, casting doubt on science, demanding higher standards of proof before restrictions could be placed on their products, and critically reframing environmental regulation as a matter of managing costs and benefits. These calls were spearheaded by the National Industrial Pollution Control Council, established by President Nixon in 1971 to allow industry executives to communicate directly with the executive. Alarmed by EPA standard setting, the Commerce Department and the Office of Management and Budget sought to restrain the regulatory agency. They did so by establishing in 1971 a quality of life regulatory review program that required regulatory agencies to prepare regulatory impact assessments describing the costs and benefits of all proposed major rules. Although this program theoretically applied to all regulatory agencies, in practice it was used primarily to vigorously challenge the EPA's regulatory initiatives. Industry also pushed for legislative change. And in particular, the 1973 oil crisis was seized upon by industry who called for an expansion of coal mining to ensure US energy security, and therefore also a relaxation of air pollution standards and extended timelines to achieve them. It was a major victory for industry when in 1981, the new Reagan administration, through an executive order, implemented a regulatory review process that was far stricter and broader in scope than its predecessors. It required regulatory agencies to prepare a detailed cost-benefit analysis of all rulemaking proposals and gave the Office of Management and Budget near veto power over regulation. Although this executive order has been replaced and updated several times, this general requirement has effectively been in place ever since. And we've seen a revised version in the past year or so, which really shows the sort of struggles that go into formulating the detail now of how cost-benefit analysis is being done. Through these struggles, cost-benefit analysis has become deeply woven in the fabric of environmental policy in the United States. This context then shaped how climate change was apprehended in US policy circles in the late 1970s and early 1980s. In 1977, William Nordhaus frames the problem of climate in terms of cost and benefit and asks to what level of control should we aspire. This question of how to optimize greenhouse gas limitation policy then underpins subsequent US policy reports. In internal US discussions about how to engage in international negotiations for a climate convention, the Office of Management and Budget and other resource and commerce-focused departments reportedly outmuscled the EPA. Internationally, they wanted to slow negotiations until a proper calculations of costs of curbing greenhouse gases could be ascertained. In the international negotiations, the US pushed for the language of cost effectiveness to be included in the UNFCCC, and Article 3, which articulates the principles of the regime, includes that policies and measures to deal with climate change should be cost effective so as to ensure global benefits at the lowest possible cost. However, again, it's perhaps through the work of Working Group 3 that the imperatives of cost benefit most directly constrained how climate mitigation possibilities were imagined. I've tried to give an incomplete history of how cost benefit came to be hegemonic in international climate policy. Now its assumed necessity is rarely questioned. Instead, we have seen the politicization of all the technical questions that go into how such an analysis is done, what discount rate is applied, what value is attributed to life. In concluding, it's worth making explicit the political stakes of such technical questions and the real violence they often mask. In its contribution to the second assessment report, Working Group 3 discusses how global estimates of monetary damages for climate change, and I quote, reflects inter-country differences in wealth and incomes, and that they thereby give a different monetary calculation to an equivalent impact in two countries. But it's the mid-range scenarios presented in this report, developed using this methodology, that's premised on the unequal valuation of life, that informed the EU's commitment to 2 degrees. The final story that I want to tell is about how flexibility and substitution entered into target setting. And this is the story of the now ubiquitous idea of net zero. The term net zero does not appear in the Paris Agreement. However, Article 4.1 states that parties aim to reach a global peaking of greenhouse gas emissions as soon as possible so as to achieve a balance between anthropogenic emissions by sources and removals by sinks of greenhouse gases in the second half of this century. The political story of how net zero came to be in the Paris Agreement is one of well-meaning political activism. Lawyer Farhana Yamin, who is attributed of having the initial idea of net zero, seized upon the message of the 2014 Fifth Assessment Report that limiting warming to 2 degrees required substantial immediate reductions and near zero emissions by the end of the century. Her motivation was simple, and I quote, "In your lifetime, emissions have to go to zero. That's a message people understand." According to reports, the concept was formulated at an August 2013 Scottish country retreat attended by a group of female climate leaders, or self-described lionesses. After the publication of an influential report that Yamin co-authored, the idea gained traction, and a lead up to Paris, it was endorsed by the OECD Secretary General, UN Secretary General Ban Ki-moon, President of the World Bank, Kim, and other global leaders. At Paris, Farhana Yamin advised the Marshall Islands, who spearheaded the High Ambition Coalition, as they pushed for the inclusion of net zero and referenced limiting warming to 1.5 degrees in the text. The Paris Agreement then marked the start of the institutionalization of net zero, which has subsequently become the new focus of climate policy. Yet even before Paris, climate justice groups were warning that adding net to the language of zero emissions was likely to delay or undermine real action, while driving land grabs that target the world's most vulnerable and further threaten food security. Given the history I've already described, the emphasis of sinks over sources, and the massive financial and political investments in schemes such as REDD, it shouldn't be surprising that net zero has indeed been taken up in problematic ways by dominant interests. But in order to understand why focusing on removals by sinks became understood as necessary and not simply just possible or desirable, we again need to turn to history, and this time the history of climate modelling. The 1973 oil shock and the political and economic chaos it produced in the oil importing world was the catalyst for the birth of a new discipline, energy policy modelling. In the 1980s, Stanford's Energy Modelling Forum developed one of the first integrated assessment models, or IAMs, for the climate. IAMs are defined as approaches that integrate knowledge from 2 or more domains into a single framework. And there are 2 basic types of IAMs: cost-benefit models that seek to identify optimal climate policies, as well as more complex and sophisticated, detailed process-based IAMs, which link various modules representing the global economy, energy, land, and climate systems in order to understand the trends in energy technology and use, land use, and social trends, and to analyse different transformation pathways. The purpose of such models is not to predict the future, but rather outline different pathways of how the future might evolve and therefore provide policy-relevant insights. IAMs are based on scenario planning, a future technology that departs from classical forecasting. Unlike forecasting that draws on deterministic and quantifiable methods to predict the future, scenario planning posits in narrative form a plurality of contingent possible futures that could be actively and creatively brought about within dynamic, evolving social structures and relationships. The purpose of scenario planning is to enable decision-making in a context of radical uncertainty and unknowable contingencies. And is initially developed in the context of Cold War defense planning, the use of scenarios surged in the late 1970s in response to the decade's interlocking monetary, economic, and energy crisis. One of the most famous and prominent adopters of scenario planning is Dutch Royal Shell, but scenario planning has come to inform strategic planning in a number of domains, including military, corporate, political, and environmental planning, making them, as Melinda Cooper suggests, perhaps the most ubiquitous and most consequential epistemologies in contemporary politics. So after it was formed, the nascent Working Group 3 of the IPCC convened modellers to develop and approve scenarios through an intergovernmental process. The first set of scenarios were developed in 1990 and then updated in 1992. And by 2000, they developed 40 scenarios organised into 4 families, accompanied by storylines and narratives to help interpret them, each of which was treated as equally valid with no assigned probabilities of occurrence. The development of the current generation of climate models started around 2007. And while the previous process was sequential, the current process is parallel. And there's a new process to redevelop scenarios undergoing at the moment. So I'm speaking about the ones that were currently used, but noting that there is a new process to develop new scenarios underway at the moment. And this process involved first the development of a number of representative concentration pathways organised around levels of radioactive forcing in 2100. And in parallel, 5 socioeconomic scenarios called the shared socioeconomic pathways were developed. And each of the 5 shared socioeconomic pathways has a name: sustainability, middle of the road, regional rivalry, inequality, and fossil fuel development, and is accompanied by a narrative. The narratives are intended to provide broad descriptions of future conditions while being sufficiently generic to stand in for a range of contingencies. This scenario planning, one could say, is probably one of the least imaginative, yet most consequential works of CLIFI. And there have been a number of important critiques of scenario planning, which help illuminate some of the key problems of how the IAMs are operating and how they're being used. First, literary scholar Simon Oparna has argued how the temporality of scenario planning is characterised by a double movement of promised freedom and sometimes not so subtle reinscription. He argues that they work in the service of dominant interests by expanding our horizon into a set of imagined possibilities that, through their unstated assumptions and omissions, simultaneously limit how we think about present and future possibilities. In climate science discussion, there's growing awareness of how these assumptions shape these models, and thus our understanding of what constitutes possible and desirable ways to respond to the climate crisis. In particular, critics have highlighted how these models contain very conservative assumptions about the cost of renewables, that models are constrained by the need to identify cost-benefit mitigation pathways, that models assume the inevitability of economic growth, and that they fail to include north-south equitable considerations. Critics of scenario planning have also highlighted that scenarios are not simply descriptive of contingent future possibilities, but actually operate as means of making futures present, based on acts of creative fabulation. They have thus been described as exercising a world-making power in bringing futures into being. The performative effect of these models make them a means of world invention and tools for the actual shaping of present worlds, given how images of the future shape and structure our actions in the present. Within the climate policy, the current generation models are increasingly treated as prescriptive rather than simply descriptive of policy options. And these problems have very real consequences. So prior to 2007, there was almost no modelling consistent with limiting warming to 2 degrees, let alone 1.5 degrees. Yet around the time of Paris, modellers were suddenly asked to model for more ambitious temperature targets. The models, which were constrained by the need to identify cost-effective mitigation pathways, struggled to develop feasible pathways. The solution adopted was to introduce negative emissions technologies into the models. But by doing so, some climate scientists now worry they basically opened up Pandora's box. Now, the overwhelming majority of scenarios that limit warming to 2 degrees rely on overshooting and a large-scale use of bioenergy with carbon capture and storage, or BECCS, to come back to net zero in the second half of the century. So BECCS involves 2 technologies: firstly, the growth of biomass through tree plantations, which operate as a carbon sink, and secondly, the combustion of this biomass to produce bioenergy, alongside the use of carbon capture and storage technology to catch CO2 released and store it geologically or in concrete. And while we're at the point where we really need to consider all mitigation and carbon drawdown options, my concern is that climate action in the present is being shaped by models that are premised on the deployment of untested negative emissions technologies that face perhaps insurmountable obstacles to ever being developed at the scale envisioned. Such negative emissions technologies have therefore been described as speculative technologies, or a technological imaginary, or even climate unicorns, as they exist predominantly in the minds of modelers. Moreover, the sheer scale of biomass needed, which according to many models would be double the size of India, raises profound questions of social equity, especially given existing pressures from competing land uses, which are already shaping interhuman and human and more than human interactions. So hopefully throughout this talk, you've identified various intersections between my three stories on climate targets. But I think these stories come together most problematically in how assumptions of cost optimization are embedded in models and the fantasy of substitution between emissions and sinks, and how it closes down political debates about climate futures. The discursive promise of the future deployment of negative emissions technology is operating as a spatio-temporal fix that licenses the ongoing combustion of fossil fuels and authorises further unconscionable delay in reckoning with the massive structural, political and economic transformations that climate politics demands, while simultaneously materially constraining possible futures. So where are we at now? Firstly, as an aside, it feels worth noting that Farhana Yamin has moved away from international negotiations and a couple of years ago joined her local Extinction Rebellion chapter and glued herself to Shell's office. But more broadly, I think we're in a moment where each aspect of how targets are being understood in the international regime, how they've been framed, how they've been quantified, and how flexibility has been introduced are subject to serious political contestation. For example, because of the insistence of developing countries, the recent IPC sixth assessment report includes a breakout box that unpacks the black box of assumptions that go into an integrated assessment model. A recent UN expert report insisted that you cannot claim to be net zero while continuing to build or invest in new fossil fuel supply. And in this context, it seems politically useful to excavate and politicise the way in which technical decisions have shaped the construction of targets within the regime. But if we step back and return to the problem that after 30 years of international negotiations on climate change, we still haven't bent the emissions curve, it helpfully highlights also the fundamental difference between targets and limits. It brings into sharp relief how the post-Paris international regime is organised centrally on the idea of targets and accountability. That is the obligation of countries to explain and justify their conduct to the international community, rather than any actual legal obligations that impose limits. The primary mitigation obligation imposed by the Paris Agreement is a procedural obligation focused on conduct, not results. Parties are required to prepare, communicate, and maintain successive nationally determined contributions based on their own perceived national interests that they intend to achieve. The aggregate of these pledges is not required to add up to 2 degrees, let alone 1.5 degrees, and we know that they don't. Countries are not even required to achieve their self-determined targets. The main compliance mechanism is the global stocktake, the first of which took place last year, that will take an inventory, and countries will be asked to publicly explain and justify their conduct in setting targets and the process on achieving them to date to the international community. Arguably, the way in which targets have been constructed in the regime will make it more possible for countries to provide an account that justifies unconscionable delay in reckoning with the massive structural, political and economic transformations that climate politics demands. But I think it's also crucial to think about whether and the extent to which the regime is organised around limits. And here I find Foucault's discussion in both the biopolitics lectures of how liberalism is structured around a principle of limitation that's intrinsic to the art of government, or an internal regulation of governmental rationality so helpful. He describes this as a de facto rather than a de jure form of limitation that impacts on governmental practice and conceptions of what operations should be carried out and by what means. It is, he suggests, a form of internal self-limitation of government reason that is made possible by the discipline of political economy and the specific forms of calculation and rationality. So I suggest that what we've seen at each stage of the construction of the international climate targets, how they are framed, how they are quantified, and how flexibility has been introduced, is the co-construction of the specific modes of calculation and the forms of rationality that make possible the internal self-limitation on the modalities of action that can be pursued by the fledgling forms of supranational authority being established by the international climate regime. Concurrently, however, The way international climate targets have been constructed has meant that novel forms of global authority, enlivened by a claim of common concern over greenhouse gas emissions, has a constantly expanding spatial and temporal reach. As a result, such authority in the name of this common concern is unevenly enacted, authorising gradualism in parts while making the potential future enhancements of sinks in the global south increasingly a subject of global administration. So inclusion, where to from here? While a strand of ecological legal thinking is concerned with reasserting a form of law grounded on the natural laws of nature as an external limitation on governmental action, I worry about some of the implications of this. Rather, I keep struggling with how we can imagine and craft jurisdictional arrangements that provide an internal self-limitation on legal authority based on the obligations we owe one another to ensure the conditions necessary for ethical cohabitation of this planet. Against the universalist aspirations of modern law, it feels necessary to insist on forms of jurisdictional ordering that place limits on legal authority, because only in limiting claims to legal authority is it possible to have a meeting of different laws, or make a space for the infra or the in-between that structures cohabitation, and thus allows for a plurality of forms of life that are not all constituted by fossil fuel dependencies or premised on economic efficiency.